Are y'all still there?
Yep.
Okay. I think obviously the featured guest is not on yet, so we will wait a couple more minutes and give some other people a chance to still call in. So if the line goes silent for a couple of minutes, don't think that you've been disconnected or anything like that. We'll be right back with you.
Okay.
Hi, Ralph, Dave Trobert, and James Franco here in Wichita. Thanks for joining us.
Hi, Dave. Hi, James.
Good morning, Jay.
What's going on?
Oh, a little bit of everything. We have a few callers online here, and Ralph Benko. We're going to wait just a couple of minutes to give a chance for a few other reporters to join us, and then we'll get started.
All right, I got to flip some switches, so don't disconnect me.
Okay.
Check, check, check. How is the weather in Wichita? Is the Wichita lineman still on the line?
It is, well, actually, they're hanging on for dear life trying to find shade under a tree somewhere. It's supposed to be cooler today, only 103.
Oh, my gosh, and I thought we were bad here at 99. I'm going to stop whining.
No, it was, Saturday was a record at 111, and when my wife and I were watching the Weather Channel, and I pointed out the humidity was only 18%, so it was one of those dry heats, and she got threw something at me. When it gets to triple digits, I don't think there's any such thing as excusing a dry heat. It's just plain hot.
My oven has dry heat. I don't want to live there either.
I think I saw Sunday that the heat index in Topeka briefly touched 120 degrees.
Oh, my.
Holy mackerel.
Maybe if we could arrange for some of that to get in under the dome, we'd have legislation move a lot faster to get out.
Well, some people make a very plausible argument that the decline of America coincides exactly with the invention of air conditioning because Congress used to clear out and stay away for long stretches of time, but once they could air condition.
Gene Meyer.
Has joined the conference. The caller has joined the conference.
Hey, Paul.
Hello.
Hey, Paul. George Washington gave that as a reason why he donated the land, the swampy land for the Capitol. He said at least there'll be a few months here where the Republic would be safe.
Well, darn the carrier company. I never thought I'd find myself in the company of Luddites, but in this one case, I'll make an exception.
Well, let's go ahead and get started. Again, my name's Dave Trobert. I'm president of Kansas Policy Institute. Just let me give you a little background on why we're releasing this paper and what it's intended to accomplish. Resolving the enormous unfunded liability of Kansas retirement system, also known as
caller.
I'm Mark Palmer.
and ensuring the plan's solvency is one of the greatest challenges faced.
Has joined the conference.
Most states have serious pension problems, and Kansas has one of the worst, unfortunately. based on current asset values of the last report, the plan is only 56% funded. That's one of the lowest ratios in the country. The commonly referenced liability is $7.7 billion, but that is not counting $1.7 billion in losses that have already incurred. KPERS acknowledges that the current asset value liability is 9.3, but even that's low because that's based on an 8% annual investment return, which KPERS also acknowledges is probably too high. They're considering right now reducing that and say that a half-point reduction would add another $1.3 billion. So if we were to look at a more realistic return of, say, 6% going forward, that pushes the liability over $14 billion, about double what people think we really have, which already is a bad number. Solving these problems really requires full knowledge of all the options, and there are many legislators in Kansas and around the country who believe the law does not permit any change to existing benefits. But as Ralph Benko will explain, the law does, in fact, provide that option, and in order to be able to make these very difficult and informed decisions, we need to know what all the options are. With that, I'll...
Join the conference.
Ralph?
Yes, here I am.
Go ahead.
Yes, we're not here to tell anybody what to do. We're just here to tell people, what the federal Constitution permits them to do, so that the policymakers can, exercise the range of options that's available to them. And one of the things we would like very much to do is sort of dispel the idea that there needs to be some kind of federal legislation authorizing state bankruptcy, which currently doesn't exist. We think that that's, completely unnecessary, that the constitutional provisions at the federal level permit states to make reasonable unilateral adjustments already and don't need to go through a bankruptcy process. So we see that as kind of a waste of energy and not good process. So, given the the clear black letter of the defining precedents on the contract clause of the federal Constitution, one of which is Energy Reserves Group versus Kansas Power and Light, so chickens come home to roost. The other being U.S. Trust Company of New York versus New Jersey. It seems unequivocally clear that the Supreme Court has ruled that a state may impair a contractual right if it has a significant and legitimate public purpose, such as remedying a broad and general economic problem, such as the elimination of unforeseen windfall profits, which is relevant here because since government accounting is not bound by generally accepted accounting principles, meaning that they can operate on a cash rather than an accrual basis and do, then a lot of these problems were, unforeseen and kind of kicked down the road to the point where they, grew to a point where they are threatening the ability of states and municipalities to provide essential services and have become a sort of bipartisan. There's been a bipartisan recognition that there has been a systemic breakdown, providing obligations that are, unreasonable, unjustifiable, and disproportionate. And by simply bringing them back into line with private sector, with private sector benefit packages, then states can move a long way down the road toward rectifying this problem without either shutting down essential services or imposing a tax burden that's unsustainable on the general population. And this is a myth. This dispels a myth that's been that was very widespread before our research began to circulate, that somehow these benefits once voted were sacrosanct, and there are acres of constitutional doctrine that simply say that's not so, it can't be so, and that's a myth that is that is long overdue for being dispelled, and it's being dispelled. So we see this beginning to move all over the country. I don't know how much of this was precipitated by our research, but even at the federal level, there are being adjustments to the retirement benefit packages of federal civil servants that are very substantial. It's happening in the UK as well, and it's beginning to happen in state after state, as it really must. And it's a legitimate thing to do if it's done in a legitimate way, which is to say that if it's done in a way that's reasonable and necessary. And from our perspective, as looking at the federal constitutional law here, we're not an expert in the various state laws. We're just being responsive to various states who want to know, what the federal constitution prohibits and permits. We're saying, look, at the federal level, there may be state constitutional requirements that we're not familiar with. Some states do have that. But at the federal level, you're fine as long as you're...
state constitutional protection, any language in the state constitution, has it been amended to protect public employee pension benefits?
I'm sorry, were you addressing that as a question?
Yes. 31 states have in their state constitutions amendments that to one degree or another forbid impairment or diminishment of public employee pension benefits.
Right, and some of those states are looking to...
I just wondered if Kansas had any a state constitutional amendment.
Not that I'm aware of, Frank.
Okay.
Okay. Ralph, you want to finish up your points, and then we'll open up for questions.
Well, I think I basically made the statement. It's the language in the Supreme Court cases, the governing cases, is exceptionally clear. We have quoted it verbatim in the paper that you have issued. We've provided an appendix that gives some of the specific doctrines and some of the specific language. And anybody. It's actually clear enough that even a layperson should be able to follow it if they want to go to the cases themselves, which is easy enough to do on the web.
Okay, Ralph, you might address, you do address this in the paper, but there have been some court cases that certain pension changes couldn't take place. But you point out that those are very narrow and not on target here.
Thank you. That's a very good point. Yes. I looked into scores of state court cases and circuit court cases that are often cited by people who are, opposing adjustments as, precedent against the ability of the authorities to reduce benefits. But in every case that I looked at, and I think I caught most of them, if not all of them, it was specific and punitive, and it was totally outside of the energy reserves or the U.S. trust doctrine. So somebody may have been fired for having breached a felony or for having committed a crime or something like that, and they wanted to take away his pension as part of the penalty. And no, they were not permitted to do that. But when you're talking about none of the cases that I've looked at have been litigated on the clear grounds that say you can impair a contractual right if you've got a legitimate public purpose, such as remedying a general economic problem, which is exactly what we have now.
Any other questions for Ralph?
Let's suppose that the legal authority exists to change existing retirement benefits. What about the political will? Can you speak to that at all? I mean, is this something that could be done in a political climate where you have state employees who vote who may be against this?
Well, that's that's not really a policy question, but one of the things that makes me believe that this is not just doable, but inevitable to some degree or other. It's a matter of how much rather than whether. Is that this has become a valence issue that even prominent liberals like Joe Biden are in favor of it. even the Washington Post, which is heavily read by career civil servants, of which I was, by the way, for several years, and my father was before me for a career. There hasn't been much complaint about it. If these benefits, and remember, we're talking about scaling down disproportionate benefits and unjustifiable benefits. We're not talking about taking it out of the civil servant's hide, taking out other improvidence on the civil servant's hide. There's been a strange breakdown, and in which the people who the authorities were, got civil service employee union endorsements, votes, contributions, and so forth for contracting for benefits that they themselves were not responsible for providing. That would not begin to manifest until many years down the road, where we now are. So there's a kind of moral hazard at stake here, in which elected officials, can bring in endorsements and can bring in votes and can bring in volunteers and can bring in contributions, and not have to confront the costs of that. The costs are something to be confronted by their successors. So in my viewpoint, because they don't have to account for these expenses because of the exemption of state governments and municipalities from general accepted accounting principles, there's a severe moral hazard that was created by the system, and then there was a systemic breakdown. And so the systemic breakdown, has created in some cases, in many cases, retirement benefits that are, enormous and out of proportion to the private sector, which is creating a huge weight on the cities and the states. So someone like Gavin Newsom, the unequivocally liberal mayor of San Francisco in his day,
has joined the conference.
When Gavin Newsom was mayor, he was complaining that he was having to shut down hot lunch programs in senior citizen centers because the pension obligations for firefighters who would retire at $100,000 a year at age 50, were just staggeringly expensive. Andrew Cuomo, when he was running for governor, which he now is, another unequivocal liberal, was quoted in the New York Times as deploring the fact that a firefighter might be able to, through the manipulation of the system, retire at age 50 at $100,000 plus a year pension. This is not a disabled firefighter who did something heroic. It's just he worked in the system and worked the system for 25 years and then retired at age 50 at $100,000 a year, or $102,000 or $8,000 a year, or something like that. I was talking with someone. This is anecdotal. I didn't read it in the press, but it was a nurse who, by working with the public system, she had to retire at age 55, I think it was, at $147,000 a year pension, because that's what had been negotiated by the public employee unions. And I belong to public employee unions. I've got no animus against them. Their job is to get the best job as they can for their members. But when the system breaks down and the officials are sort of giving away the store, then we need, when the chickens come home to roost, as they are now doing, we need to loop back and say, everything that's unreasonable really needs to be given back.
Yeah. Hey, Ralph, the cases you studied, how clearly do the courts define what is proportional or proper here?
They don't. Okay. The standard. This is a rule of reason kind of thing. They just say, there are these two major Supreme Court cases that you can see for yourself. But reasonable is reasonable. It's just reasonable and necessary is sort of a common sense kind of standard, and that's what we proposed when we advised ALEC on formulating model legislation, that we use that they use the private sector as a reasonable standard, and it seems hard to argue against the reasonability of that.
Sir, how close does the financial calamity have to be to making these sorts of changes? I mean,
Well,
does Capers have to run out of money like on Wednesday or in 28?
Here's the language, right? A contractual impairment may be constitutional if it is reasonable and necessary to serve an important public purpose. I would argue that, you don't have to wait until it's imminent. There's no language in any of these cases that say that it's got to be a clear and present danger kind of thing. The longer you wait, the harsher the measures need to be. And so it seems, like a perfectly reasonable exercise of discretion to say, let's get this under control now, where we have to impose the minimum amount of austerity in order to get this under control. If we wait till the last minute, then it could be really, yes, catastrophic to the retirees.
At what point are retirees, those actually having retired, can we mess with their benefits?
I would guess yes, but I would also guess that you've got a higher level of reasonable expectation there, and you'll also have a more sympathetic, you have more public sympathy for people who have who've spent their lifetime in the system and then retired. Their expectations are more set. So I would say technically, I haven't found any reason that you wouldn't be able to do that, but practically you would have a higher standard to meet and a much higher political hill to climb. And I don't really think that that's probably necessary, but I'm not an expert on Kansas's situation, and I defer to the policymakers there as to, how far they need to go. And if there are current retirees who have, who have unjustifiable benefits, ridiculously high pension benefits, making twice what if you can retire at age 50 and collect twice what your average worker in Kansas is making, what your average family of four is making, then I'd say you had a sympathetic case to say that needs to be scaled back. Now that's harder. It's always harder to take something away than to deal with an expectation. So whether the policymakers want to do that or not, it's entirely up to them. It depends on
some of the cases, I believe, have considered benefits already earned to be property. So it's a property right, not a contractual question.
I'm sorry. What cases are those?
Well, I don't have them right in front of me. I was just looking through on my. There's been a lot of stuff written about this.
There was just a Minnesota case recently.
Yeah, I think so. I've got so much stuff piled into my folder I can't find it. But if
listen. Property rights are a function of state law for sure. Okay, there isn't. My role here is to say that there's a myth that the federal Constitution makes these benefits sacrosanct.
Right.
I think that's a very hard position to sustain. That you've gotten you have an expectation of certain benefits under a contract, and therefore it converts somehow from a contractual right to a property right. I need to look at that particular case to say, but remember, in Fletcher versus Peck, one legislature can't bind a future legislature. You can't surrender your police powers, your powers to govern the jurisdiction, by committing a contract. I mean, that is really very fundamental. So for a court to rule that, these are property rights and can't be taken away without due process of law, it's an interesting line of argument, but I'd say that that's a high hill to, sustain. And there may be states that, take that position, but, kind of then what?
Ralph, let me jump in because you mentioned the policy issues of this versus the legal authorization, and just make a couple of comments. First, let me reemphasize what Ralph said at the beginning. This is not in any way proposing that something should be done. This is simply saying that the law allows any changes to be part of the mix for those making the decisions to consider. And while it's natural, I think, that we all leap to, is it possible to reduce somebody's pension that they're already receiving or about to receive as kind of the worst case scenario. I don't believe that anybody is seriously entertaining that. But what this does do is, I mean, there's an awful lot of other options that it opens up that otherwise might not be considered. For example, changing the provision in KPERS that allows people to buy service that was not state working for the state or local government, being able to buy military service or being able to buy credits to get service as a local school board member. Legislators who are credited with a full year's service, I think it's 372 days, instead of what they actually worked. There's a lot of those types of things that also become possible to consider making those changes and understand how, if they made those changes, what impact that would have on long-term liabilities. So,
yeah, and when you're dealing in this realm of multiple possibilities, one of the most interesting proposals I've heard is a buyout, which allows people to convert their their contractual rights into actual property rights, where they say, okay, look, I'll take $50,000 or $100,000 or whatever, some certain, and it goes into a 401k equivalent for me. Okay, that is now my property. That can't be touched. It's outside the system. It's my property, no question about it. It removes the uncertainty, and it allows for a consensual composition a consensual composition which can reduce the threat of the obligations and allow a higher level of certainty on the part of the future retirees. I don't know if that's being proposed in Kansas, but that's the kind of creative thinking that this allows people to undertake.
I had a question. Is there any difference in the law between the private sector and public sector regarding modification of these pensions?
I'm not sure I understand.
Well, I mean, some private companies still have defined benefit pension plans similar to these public sector plans, government plans that are causing so much trouble. Are they private sector companies trying to do these same type of modifications, and is the law similar or different simply because it's private versus government?
Oh, sorry, it's just beyond the scope of my expertise. I was simply asked to look into whether these, whether retirement obligations were, sacrosanct under the Constitution of the United States, or whether they can be adjusted by government authorities, and they can be adjusted, under the right circumstances, such as those prevailing today. If it was a private company, it would be kind of different calculus. It would be a more complicated. It would be far more complicated argument to make that the government can intervene and basically pass laws, capping people's pensions for a private company. This is a general area that has to do, among other things, with the fact that governments don't use generally accepted accounting principles. It's actually kind of shocking. A lot of people are not aware of that.
Mm-hmm. Well, thank you. And what happens to if a city or state were to declare bankruptcy? What would happen to these pension obligations? Can you just brief us on that if you're aware?
Yeah. Well, first of all, states can't. There is no provision for states to declare bankruptcy. There are provisions for municipalities to do it, and some of them have. Like I believe Vallejos, California. You can Google that if you like. I'm sort of aware of it. I haven't specifically researched it. And in that case, there is, as in every bankruptcy, there's a trustee in bankruptcy that is appointed, a magistrate, to go over all of the various different obligations and so forth, and to assign, who gets, what creditors get paid. And since retirees and workers are creditors of a sort, then the magistrate would decide that based upon his or her view of the equities.
Mm-hmm. Well, thank you. And my final question would be, some proposals, of course, are to in the defined benefit plan for new employees and put them on a defined contribution plan.
Oh, that's ubiquitous, and it's almost certainly the wave of the future.
Yeah, and my question would be, what about people in mid-career that are already working under a defined benefit plan? Does the law say anything about ending the defined benefit plan for them, honoring those commitments already made, or perhaps reducing them? I don't know, and then starting them on a defined contribution plan from that time? Is there any legal ramifications that would prevent that from happening?
I know of none. I know of no legal bars, provided it meets the test of remedying a broad general economic problem and doing so in a reasonable and necessary way to serve an important public purpose. It's very important. The private sector went from defined benefit to benefit to defined contribution a long time ago, and it's more or less inevitable that the public sector will too. And the question is, what are the transition issues?
Thank you.
Sir, does it make a difference if a state has implicitly said that it is not paying market wages?
Does it make a difference if a state? Okay, can you?
Yeah,
I'm not sure I understand the question here. So go on.
Here in Kansas, we have a group that is trying to bring state employee wages to market levels.
Yes.
Indicates that there's a presumption that state employee pay is not at market levels.
I'm sorry, is it above market or below market?
So far, we found that state employee wages are below the market for similar skills, tasks, that sort of thing. Does that tend to be something that will make it difficult for a state to make pension changes?
Well, I guess the question is
of inadequate wages that somehow goes into the pension system.
Well, the wages and the benefits are all part of the level of security and so forth are all part of the overall pension, are all part of the overall compensation package. And the court will look at everything. When the court is determining whether it's reasonable and necessary to serve an important public purpose, they're particularly when the state is trying to adjust its own obligations, the court will look at that very seriously. This is not a carte blanche for states to do whatever the heck they want at the cost of whatever promises they've ever made. Okay. The question is if these benefits, if there are in fact unforeseen windfall profits, and if there is a general economic problem, and if the remedy is reasonable and necessary, then the states can do that. If they're being unreasonable, then no, they can't. They cannot. This does not give them the power to be unreasonable.
If I might add one more question, the state art caper system has, I believe, 3 different programs, 2 of which are financed nicely. The larger one that includes the general state, the judges and the police and fire, those are funded pretty well. Can we blend under the same umbrella of capers their money with other money?
I don't know enough to give you an intelligent answer to this. Okay, I don't know enough about the specifics. Remember, what I did was I looked into the federal constitutional law to describe whether there were any federal constitutional constraints on reducing excessive benefits. And the answer is no, there are not. That seems crystal clear.
Okay,
now, if you're getting into the specifics of your state plan and what's funded and what's not and what's reasonable and what's not, thank goodness you've got the Kansas Policy Institute right there, very smart people, and they'll be able to answer your questions, I'm sure, to your satisfaction.
Yeah. Hey, Ralph, here in Kansas, another question that's going to come up is is the IRS going to say grace over this thing and allow such a change if one is ordered? Have you or anybody else that you know of looked into that question?
No, but I'm not even sure what that question is. You're only tax. Is
it okay under?
You're taxed on your income. If you don't get income, then you're not due taxes on it, right?
No, it's more whether
the IRS have to say?
It's more whether perhaps whether will that money be taxed when it's put in, or it gives into tax delays and or just the very nature of a defined contribution plan. There are some IRS requirements for one to be declared kosher.
Yeah. Oh, yeah. No. When moving to a defined contribution plan, there are specialists in this. I used to do this I did a little bit of law like this back in the days when I was actively practicing. Okay, and there are the ERISA guidelines and so forth are or whatever it is now are extremely specific and mathematical, and there are specialists in there who make sure that you are in compliance.
Mm-hmm.
So I don't see that as a problem, but I do think that it's really very valuable for people to start thinking in terms of how do we get to a defined contribution plan so that the taxpayers and the service and the essential service recipients are not stuck by a never land full of exorbitant but politically expedient promises that are witheringly expensive and way disproportionate to what's practical. And that's exactly where KPI is pushing this to try to figure out what's reasonable. And you've got a big problem. Now you need a big solution. And part of the big solution is to make sure that any unreasonable obligations are not treated as if they're somehow sacrosanct.
Ralph, if I could, we're getting close to wrapping this up, but there is a difference. One of the questions just asked about IRS, for example. A lot of these issues would only come up if there were very significant changes to existing benefits, say, for current retirees, or if you were freezing a defined benefit plan and putting everybody into the defined contribution plan. But aren't there an awful lot of changes that can be made that legally can be made that don't go to that extent? For example,
absolutely.
What is the legal difference between, or is there one, between changing benefits? What's the legal concept of when a benefit is incurred, I guess? For example, for people who have, say they're 45 years old and still considerably away from retirement, changing the formula of how pension benefits are calculated for years not yet worked is a wholly different matter than changing the benefits of say, a retiree who's already collecting benefits.
Mm-hmm.
Is it correct that those kinds of to, say, in the case of Kansas, changing a multiplier or changing the retirement age, or
increasing COLA adjustments or increasing employee contribution rates? Yes, there are lots and lots of perfectly kosher, uncomplicated things that you can do to ameliorate to shift the burden to the point where it's equitable with what's kind of normal for the workers of your state. And there are just a lot of tools in this kit, and all we're trying to do is to say that people who say you can't, these are off the table, you can't touch them, just don't have a legal leg to stand on. They just don't. As long as it's as long as you're being reasonable, and there are a lot of reasonable ways to address these things. We're not talking about doing anything outrageous here. We're talking about addressing, we're talking about redressing outrageous benefits. We're talking about redressing benefits that are just not, that are a function of the manifestation of a moral hazard of cash basis accounting rather than accrual basis accounting, political benefits, and costs to be pushed down the road. Costs now beginning to accrue in ways that both liberals and liberals as much as conservatives, Democrats as much as Republicans say, hey, this can't be. We can't we can't shut down all of our senior citizen centers because we have provided egregiously over-rich benefits. I mean, to public employees who retire young and at an incredible rate. I think I read somewhere. Please don't quote me without looking it up. But the chief of police in San Francisco retired at age 50 at something like a $500,000 a year pension for life, inheritable by her husband. Now, it might have been $250,000. I don't have this story at my fingertips. But what are you going to do about something like that? That's just, it's preposterous. And to say that that's constitutionally protected, our point is that's also preposterous. So please don't misinterpret this as saying, oh yeah, we're going to take this out of the hide of the teacher who worked inside the system, the hero teacher who worked inside the system for 35 years or 40 years, and is now retired on a $35,000 a year pension. That's not what this is about. This is about addressing the abuses and the moral hazards here, so that we can scale these benefits back to the point where it doesn't get in the way of providing essential government services, and it doesn't call for draconian tax increases that's going to drive all of your young people into the neighboring state.
Mr. Benko?
Yes, sir.
Were most of those benefits passed legislatively? I mean, they were legislative actions that enabled them. So whatever a legislature can do, a legislature can undo, right?
Correct. Yeah, I don't know that they were legislatively passed. I just don't know about the TikTok. But it's absolutely true. Whatever a legislature can do, a legislature can undo. That is fundamental law in the United States. One legislature cannot bind a successive legislature. And by the way, there's also another moral hazard that I'd just like to lay down here and make sure everybody's sensitized to. A lot of the judges are in the system. So one of the things we proposed in our model legislation is that if this needs to be litigated, it be litigated in the federal courts, because otherwise you have a terrible, unsustainable problem of at least an appearance, if not a reality, of a conflict of interest, where a judge is passing on a legislature's adjustment of his or her own pension. Okay, that is against all of the canons of ethics, even the appearance of a conflict, and that's a tough thing to get around. So there needs to be a mechanism by which you get around that. But people, if they're talking about what did the court say about this, I'd like them to be asking the question right up front, saying, and is there a conflict of interest in the court ruling on this? If the Minnesota courts have held that, and I'm not saying they have or haven't, but have held that there's an inviolable property right to the pensions that they've been promised, that's awfully problematic if they're the beneficiary.
Well, if you take that, since many federal judges, started their careers as state judges, I mean, do we have to take this to the College of Cardinals to get a decision?
And what's their pension plan like, right? No, you can have a judge, if a judge's interests are touched on this, you can, it's standard practice for the judge to recuse herself. So if a federal judge is started off as a state judge, then it seems to me that's a real good issue for whom their pension is involved. It's a real good case for that judge to recuse herself from. But I'm just, please, as reporters, be aware of this when you're looking at these cases and when you're looking at the litigation that is inevitable for this, because the unions are extremely alert to go to court to try to protect this stuff. Not always successfully, they fought very hard COLA reductions in Colorado and 2 other states, okay, and they were tossed out on their ears. So just because there's litigation doesn't mean that it's legitimate. But when there's litigation, please put your reporter spectacles on and say, is this judge in a real or apparent conflict of interest in this case? Because that's a very important issue that hasn't been raised as often as as often as it might.
Would whatever system, if they decided to change the benefits for a retirement system or change it structurally, does it have to be done in a uniform manner so that we don't have legislators, throwing an extra 2 points towards retirement for, someone who's been in the military or
No.
Something like
No,
that?
it just needs to be reasonable. You know, if it's arbitrary, it doesn't fly. If it's reasonable, it flies. This is an inherently governmental assessment that needs to be made. And so, you know, if they have a good rationale for the way that they're doing it, then the courts will defer to that. If they have no rationale, if it's, you know, just purely arbitrary, then the court is likely to reject it.
All right, thanks everybody. If you would like to have further discussions with Ralph, please call us here. Ask for James Franco, our communications director. The number is 316-634-0218, and James can arrange a time for you to speak with Ralph further. If you have any questions, certainly about the state of the KPI system, I would refer you to the analysis that Dr. Polson wrote for Kansas Policy Institute, which is online on our website. If you have any questions about that or would like to speak to Dr. Polson or just get a hard copy of that report, call here also, and we'll be happy to set those up. Ralph, thank you very much for your time today.
My pleasure.
The paper is going to be published forthwith, and we look forward to many more questions and as we continue to try to look at all of the options that are available, and hopefully the more of these options we find, the way we move away from the so-called nuclear option. Thanks, everybody.
Thank you. Bye-bye.
Thank you.
Bye.